Hello guys, this is Dr. Pallavi Gupta. As you know, I am teaching you healthcare law. I will discuss today, that is the negligent diagnosis by doctor. In the previous lecture, I have discussed wrongful diagnosis. Today, I will discuss negligent diagnosis by doctor. I will discuss about the topic and what is the test for negligent diagnosis and the case laws related to this negligent diagnosis, whether doctor can be held liable or not. Introduction. The duty of a medical practitioner arises from the fact that he does something to a human being which is likely to cause physical harm unless it is done with the proper care and skill. There is no question of warranty undertaking or profession of skill. The standard of care and skill to satisfy the duty in tort is that of an ordinary competent medical practitioner exercising the ordinary degree of professional skill. The test for negligent diagnosis: a professional or a medical practitioner charged with negligence can clear himself if he shows that he acted in accordance with the general and approved practice in medical line. It is not required in discharge of his duty of care that he should use the highest degree of skill, since the same may never be required by each and every individual. Meaning thereby, if higher degree of reasonable care is required in a particular case, only in that case medical professional will does. If it is not required, he will apply only the ordinary skill of care. Even deviation from normal professional practice in peculiar and special circumstances is not necessarily evidence of negligence, meaning thereby to hold the doctor liable for negligence, we have to see whether the doctor have applied reasonable degree of care in a particular case as it is required, whether doctor has to apply the highest degree of skill in a particular case and he failed to apply. As regard to the standard of care required for the medical man, it cannot be stated that a mistaken diagnosis is not necessarily a negligent diagnosis. Mistaken diagnosis may lead to negligent diagnosis, but it is not in all the cases. A medical practitioner can be held liable in this respect if the diagnosis is so palpably, means clearly, it is so obvious that the diagnosis is considered as a wrong, or to prove negligence, that is to say, if his mistake is of such a nature as to imply an absence of reasonable skill and care on his part regarding being held to the ordinary level of skill in the profession, meaning thereby doctor has diagnosis wrongly, but he diagnoses in such a way that it is clear cut of the negligent diagnosis. In that case doctor will be held liable, otherwise doctor may not be held liable if it does not lead to wrong treatment, negligent treatment. In that case doctor will not be held liable for the wrong diagnosis. But if it is a negligent diagnosis, means doctor has not applied reasonable degree of care which is required in a particular case, he fails to do, in that case he will be held liable. As although there is not a much case regarding this, but there are some case in law of torts to discuss on this point. That is the Philips India Limited versus Kunju Panu in AIR 90. Although these are the terms, in fact, which court has used in a cases. Therefore, there is a discussion. There is a need to discuss on a particular term. For example, wrong diagnosis, error of judgment, gross negligence, and this negligent diagnosis. What happened in this case? Philips India Limited appointed a doctor for the company, and the company's doctor gave treatment to an ailing employee who later on expired. The cause of the death was allegedly attributed to negligence on the part of doctor who treated the deceased for suspected venereal diseases, while actually it was a smallpox. The employees was admitted in the hospital with the disease that they are suffering from the mineral diseases, while this was the cases of smallpox. Before the trial court, one issue was framed as to whether the plaintiff proved the defendant, means doctor, treated the deceased with gross negligence and carelessness. The Bombay High Court held in this case that in an action for negligence against a doctor, the plaintiff has to prove that the defendant, means doctor, was under a duty to take reasonable care towards the plaintiff or patient to entitle the plaintiff to claim damages complained of, or not to cause damage to the plaintiff by failure to use reasonable care, means whether the doctor was having duty towards the patient or not. Second, there was patient means here plaintiff, and second, there was a breach of duty on the part of defendant, whether doctor has breached his duties. This is the second point. And third, the breach of duty was the legal cause of damage complained of, and such damage was reasonably foreseeable, meaning the plaintiff has suffered some damage, and that damage was caused due to the negligent act of the doctor. There is a direct connection, and the doctor can foresee the damage of the damage, but he fails to take reasonable care. He fails to foresee that. So if all three elements are there, only then the doctor shall be held liable for the negligent diagnosis. It is the court, Bombay High Court set aside the order of the trial court. Here the complaint was made under the criminal law. It is not the court held that it is not that the duty cast upon the doctor of a company in respect of the company's employees is any higher or lower than the duty of an average doctor towards his patient. The company's doctor is not duty bound to visit at a hospital where the company's employees are hospitalized, who is being treated by another doctor. No such duty is cast on the company's doctor under the terms of his appointment in this case. The order of the trial court was set aside as having been passed without application of correct principle of law of medical negligence to the fact of the case, and on the basis of the conjecture and summarizes an irrelevant consideration and misunderstanding the evidence on record. It was further held that the court should be careful in censoring professional men like doctors in the absence of clear and satisfactory evidence of negligence, from which the only possible inferences is one of negligence. It would be wrong to censor doctors who belong to a learned profession and who are ordinarily expected to maintain high standard of professional conduct in dealing with their patient. Meaning thereby to hold the liable for negligent diagnosis, wrongful diagnosis, error of judgment, or any kind of judgment or any kind of negligence. Plaintiff has to prove that three elements of medical negligence are there. First, duty to take care. Doctor is having a duty of care towards the patient. Second, breach of duty, doctor has breached their duty. And third, plaintiff has suffered damage, and the damage was caused due to the action, negligent act of the doctor. If these three elements are not proved by the plaintiff, in that case doctor will not be held liable. This is a clear case. In all the cases it is there. Again, I would like to say that doctor will not be held liable for error of judgment, because there may be differences of opinion where doctor has opted one and there is no opinion as such. Doctor has generated the opinion as by using their knowledge as he can. And for the wrongful diagnosis, the doctor may be held liable, may not be held liable. It will see case to case, and by applying the principle of negligence. And in the case of negligent diagnosis, doctor will be held liable as per case to case after applying the principle of negligence. If principles of negligence are proved by the plaintiff, only then the doctor will be held liable. So we can say there is no straitjacket formula to held liable for the negligence in all the cases. So this is all about negligent diagnosis. The next topic will be for remedies for medical negligence under law torts, that we'll discuss in the next topic. Thank you for watching me. This is Dr. Pallavi Gupta.